Great. Well, hello, everybody. I'm Sherry Andrews. I'm one of the co-chairs for the Practice Management Knowledge Community with AIA Chicago. Also joining me today is our guest speaker, who I'll get to in a minute, but also Ann Ross, the manager of communication or of education and awards, who will assist us at the end with some of the questions. A little bit of housekeeping. Please use the Q&A function to add any questions during the presentation. And we have left some time at the end to go over those with you guys. So welcome to our presentation today, Intellectual Property Principles and Rights for Architects. And I'd like to quickly introduce our speaker, Jeremy. Jeremy Baker, Chicago-based construction attorney, founded Baker Law Group LLC in 2019 after some 14 years as Sheffield Harden LLP, where he was a partner and member of its national construction law practice. Jeremy's practice involves project structuring across many project delivery methods, including designer-led design build, plus contract review and negotiations. Since 2015, he has served as a liaison to AIA's Contract Document Committee, which prepares its widely used contract forms. Jeremy has prosecuted and defended lawsuits in over 30 state and federal court venues, but he prefers to help clients complete challenging projects by emphasizing dispute avoidance and early cost-effective resolution of claims. Before I hand it off to Jeremy, I'd like to take the next slide to thank our sponsors for this event, the 1969 Circle Partners. And with that, Jeremy?
Thank you very much for that gracious introduction. It sounds almost like I wrote it. It was so generous. It's really an honor and a pleasure to be here with you all today. Thank you for taking a little bit of time out of your day today to talk about intellectual property for design professionals. And really what we're going to talk about today, what I hope to accomplish, is just to sensitize everybody to some very big picture issues so that you can issue spot when these things come up in your practice. We're going to be doing a very light skim of something that's really quite complicated and represents a very small portion of my practice. I'm certainly not an intellectual property attorney, but this is among the hundreds or thousands of issues that I help design professionals to navigate in contract negotiation and dispute resolution. So we're going to start off by answering maybe one of the biggest questions on everyone's mind, which is, what is the difference between having a license to use someone's plans and specifications versus having copyright ownership of that design? I'm going to move on to the basics of intellectual property rights law. We're going to talk very briefly about the difference between state and federal law and what your rights are under Illinois law and under the federal copyright law. And then what will probably be the most memorable part of the presentation today will be the third part in our agenda, where I'm going to take a paragraph that you would see in a contract and talk you through the way that I might edit it on behalf of a design professional client that I was representing, and explain the reasons why I might suggest certain edits. Certainly not legal advice for anyone, and it would be a mistake for anyone to think that they could just go with my suggested edits. They're not one size fits all for any contract or any project, but talking you through my thought process hopefully will shed a little light on what the issues are, the push and the pull, and help you to spot issues as they come up in your practice. And really what we're doing throughout this entire discussion is figuring out, how do we get past contract negotiations so that you can go do what you love to do, which is not think about contracts and words, but get on to the design of the project. I represent a lot of design professionals, and I understand that design professionals' clients are the project owners, and the owners have selected the design professional to do the job. And therefore, I have to help my architect clients not annoy their clients too much. So finding the middle ground, finding reasonable compromises when you're negotiating contracts, striving for win-win outcomes, striving for projects that are claim-free and have everybody happy at the end is really what my practice is all about. And so we're going to get into the program now. First, I just wanted to ask anybody that might be interested to guess at what was the inspiration for my law firm logo. It's a very Chicago thing, which is something that is deeply meaningful to me. And if you guess what it is and you want to shoot me an email at that address below, I will send you a Starbucks gift card. First, I should probably let you know a little bit about who I am. I'm not a real estate lawyer. I don't do any real estate lawyer stuff. I'm a design and construction lawyer, which is a way of saying that I help design professionals and project owners negotiate contracts for all kinds of different projects. 99% of my projects are commercial. As Sherry mentioned, I get to put my 2 cents in every now and again and influence the AIA's contract documents. I'm one of hundreds or thousands of people who gets to put their 2 cents in before the new standard forms are released. I've taught construction law at John Marshall Law School, and this last year I was honored to actually speak at Harvard Graduate School of Design. Before I started my law firm in 2019, I worked for large law firms for 18 years. And as a matter of fact, today is 5 years to the day since I resigned as a partner at Schiff Harden. And when I'm not thinking about architecture, I'm chasing around my 4 kids or looking through my telescopes and listening to music. And so again, this is not legal advice for you. And if there are people who are not in Illinois that are listening to this, there are principles of general applicability that we're going to cover, but these presentations don't travel across state lines as well as some others do. So this is really geared for people in Illinois that we're not even going to skim the tip of the iceberg. We're going to skim the tip of the iceberg. This is a light skim of an intensely complex topic. And this, again, is intended to allow you to issue spots. So when you see something jump out at you in a contract or a project, you can say, this might be something that I need to give my attention to. And of course, I'm only allowed to give legal advice to my clients. So none of this is legal advice for any of you. And again, if you just did to the contract clause what I am going to show you in this presentation, you might have a bad outcome because it's not one size fits all. So let's get down to probably the biggest question that a lot of people wrestle with. And what is the difference between copyright ownership and a license to use? So as soon as you draw a line on a napkin as a design professional, you own something. That's your intellectual property, and you continue to own that intellectual property unless and until you give it away to somebody else or you give them some right to use your intellectual property. So a smart owner or project developer that is going to engage you to provide architectural services is going to want to have something in the contract that says that the owner has some right to use your work. And generally those contract clauses fall into one of 2 categories. They fall into the category where the owner says, I want to own every bit of your design and the copyright, or I want to have a license to use your work. So it's generally going to be one or the other. And if you, by contract, give up copyright ownership of your drawings and specifications, you're essentially surrendering all rights in them. It's almost like putting a child up for adoption. Once the adoption goes through, the adopted parents have all the rights. So if you give copyright ownership over to an owner, you can't reuse any part of what you had in your drawings and specifications, which of course would include the standard details that you probably use in all of your projects, right? You're not going to reinvent how to waterproof the window every single time. You probably have standard flashing details. So if you give the owner copyright ownership of your drawings and specifications, technically they could sue you for infringement if you use your standard details on your next project. So there's tremendous nuance here. And of course, it should go without saying, and this is the blinding flash of the obvious, but it's something that a lot of design professionals get wrong. You can't give away more rights than you have. So if you agree to give copyright ownership of your construction set of drawings to an owner, and that includes your subconsultant's works, if you've got a structural engineer subconsultant, MEP subconsultant, if you don't have a subcontract with them that says that you own their designs, you can't give it to the owner, right? If the subcontract agreement says that the structural engineer owns their design, an architect better be very careful in the owner architect agreement to not give away rights that they don't have. So contracts on a construction project are interrelated, and if you're going to give away copyright ownership to the owner, you better make sure that's cool with your subconsultants. Now, the other category is a license to use, and that's kind of the default approach that the AIA takes. A lot of times an owner is going to delete that clause and substitute in a clause that says that they become the copyright ownership of the work. But when you merely give a license to use your drawing specifications, you're retaining ownership of your work. And the owner would have a limited negotiated right to use your work for a single project. And typically that is, you can copy the plans and hand them out to the contractors, and and then in the future, in 5 or 10 years, when they want to expand the project or they want to refresh, they can typically go back and use your drawings and plans, with or without you, in order to take the next step forward. So everything that we are going to be thinking about here, the framework is we're thinking about copyright ownership on the one hand versus license to use on the other hand. And I think that this next slide is probably my favorite because it really kind of drives home the point in a way that I've never seen anybody make the point better. And there's a couple of smart construction lawyers who I'm going to quote from here, some friends of mine who you probably know, to drive home the point that if Frank Lloyd Wright had conveyed the copyright to the owner of his first Prairie style home, there would have been no second Prairie style home, because he would no longer own the rights in that design. So, if you remember nothing else, that's the essence of signing a contract with an owner and giving up copyright ownership. Now, some of you who are high design types that, are brought in to design projects because you're intensely creative and the very best at what you do, are going to be very defensive about the idea of wanting to give away copyright ownership of your designs. Others may practice in a different area, and they might think, I don't care if I give the owner the copyright to this particular project because all my projects are inherently different, and as long as I can reuse my standard details, it makes no difference to me at all. I'm going to go ahead and freely give the owner the copyright, subject to certain caveats that we're going to get into when we look at the contract clause and how we might edit it. But if Frank Lloyd Wright had given up the copyright to the first Prairie style home, there would have never been a second one. And I hope that that's something that sticks with you all. It's certainly not my idea. I'm quoting from a couple of really smart people whose names appear on this slide deck right here. But before we go into the perhaps dry intellectual exercise of looking at that clause, I want to try to breathe a little bit of life into this by talking about how people get into disputes over intellectual property and how to avoid them. Because I'm going to talk a little bit about lawsuits and claims in the future, but it's not because I'm salivating with, interest in the idea of representing you all in a big fight. Nothing could be further than the truth. I formed my law firm to help people avoid trouble. I come from the school of nip it in the bud. If I never participate in another lawsuit ever again, it'll be too soon. 99% of my work is transactional, and I only get involved in litigation when it's absolutely necessary. But I want to tell you a story of a particular dispute that I was involved in, because hopefully it'll breathe a little bit of practical life into what we're going to discuss in a second. And to make the point that when you see claims about intellectual property violations, it really tends to come when an owner will switch architects mid-project. And I was involved in a project where I represented the second architect that came to a project. This was a tall tower in a city other than Chicago, and the owner decided to switch horses halfway through the project. And this was, a project where we had retail on the first floor and parking, and there was a podium, and there was a hotel component, and then there was condos on top. And so what the owner did is they got into a fee dispute with the first architect. They fired the first architect. They brought in my client, and my client said, okay, from this floor up, midway through the project, we're just going to start over and design everything afresh and not use the original design at all. And then they performed construction administration throughout for the entire project as it was built. The first architect sued the owner of the project for fees, and also sued my client, the second architect, saying that my client infringed on the original architect's design because the facade of the building had the same shape, and because the stairwells that sort of penetrated up through the lower part of the project that was designed by the first architect, the stairwells penetrated up through the second part of the project, the upper floors that my client designed, and the mechanical areas that vertically penetrated through the whole project from the lower part all the way up to the top also were the same. And you're probably thinking to yourself, how could any architect take over a tall tower halfway through and change where the stairs are and make the outside of the building look different? But that was the allegation against my client, is that my client, the second architect, infringed on the rights of the first architect. They sued my client in federal court. Some of the allegations even suggested that my client weren't allowed to answer RFIs that came in the construction phase if the contractor was asking questions about drawings that were prepared by the first architect. And so kind of one of the lessons to take away from this is, if you're the second architect coming to a project, you need to care a lot about making sure that the owner owns the design of the first architect, or is willing to protect you and defend and indemnify you in the event that you find yourself the victim of a claim from the first architect. And of course, the first architect wasn't trying to hurt my client so much as, exert leverage on the owner. All right. And so I'm hoping that little story will breathe a little life into everything we're going to talk about going forward, because we see these disputes when owners switch architects. A lot of times we see disputes related to fees. The architect will say, these are the additional services that I'm owed. The owner will say, I'm not going to pay it. The architect's going to say, then you can't use my drawings. And you see that push and pull. And then you also tend to get to intellectual property disputes that are sort of a sideshow to a main dispute about whether or not there's professional malpractice. So before we get into the contract clause that I'm going to walk you through and suggest how an architect might think about making edits, I want to just give you maybe the most boring part of the presentation right now and just give you really quickly sort of the background. And I'm going to talk a little bit about claims right now, and I'm going to talk about litigation, but it's not because I think that people should be litigating claims about intellectual property. It's because it's important for you to understand leverage, right? If you have your intellectual property protected, and you could protect it through registering it with the Copyright Office in Washington, D.C., or if you've got a good contract that protects you, you have the right to make claims if people infringe on your works. And that right is leverage for you, and it's something that can tend to make people not want to infringe. So I'm not suggesting that you would have claims for damages that you would actually be bringing, but that if the other side is aware that you have, that club in your bag, they might decide to not infringe. And so it's all about leverage, and it's about dispute avoidance. And as I mentioned, the first bullet point here, if you draw a line on a napkin, you own something, under state law. It's a patchwork of different laws in different states. But most of the intellectual property rights that we tend to think about are a creature of federal law. There's a Copyright Act passed by the US Congress that was amended meaningfully in 1990. And there are two separate types of copyrights. And this is a huge oversimplification. But one type is copyrights in architectural drawings and plans, which, as I mentioned, are protected by federal copyright law, the same as other types of drawings, plans, and pictorial works. The second type of copyright is in the designs of the buildings, which are referred to as architectural works. You're probably thinking, what's the difference? Well, the Copyright Act defines an architectural work to include the overall form of the building, as well as the arrangement and composition of the spaces and the elements of the design, right? And the copyrights in architectural plans and architectural works, they're different and they can be enforced differently, right? Because copyrights in drawings and plans are generally infringed when someone copies the plans without authorization, right? So in the olden days, that would be somebody, obviously I'm being facetious here, breaking into your office and taking your physical drawings out with them and stealing the paper. And now it would be more, somebody borrowing a BIM model element, a detail or something like that. But it's essentially making off with somebody else's designs. Architectural works copyrights are infringed if someone copies from the design of the building without authorization, even if they didn't copy the plans. So it'd be sort of like you sitting outside a beautiful building and, sketching what's there and, pivoting off it and using it as your own. In either case, infringement can be done by direct copying or by deriving new plans or designs from the copyrighted work. And a lot of times people come and they'll say, Jeremy, how much do I have to change a design to not infringe? And when somebody says I changed it around a little bit, they're usually admitting that they violated the copyright of somebody else. So if you're wondering how many lines you got to change to make it your own, be really careful, because if somebody says you did something wrong and you said, but I changed it around, you got to be careful that you're not admitting infringement. And parenthetically, you're all protected by professional liability insurance, and that's something that is very important to my practice because I help design professionals. Generally, and I haven't read your insurance policy, so this is a generalization, but typically professional liability insurance policies are not going to provide you any coverage for infringing, because it's like the theft of somebody else's works, right? Professional liability insurance will protect you from design malpractice when you accidentally violate the standard of care, not for when you intentionally do something wrong and make off with somebody else's design. So that's an important thing to take home with you. And so I mentioned that you can register your copyright with the U.S. Copyright Office in Washington, D.C., which is something that is almost never done. I mean, 999 times out of 1,000 design professionals don't do this. And I don't think there's anything wrong with that. But when you get into a situation where you feel like somebody is infringed on your intellectual property, the difference between having your design registered and not makes a world of difference. And registering copyrights early in the project has two main advantages under federal law. And again, this is such a huge generalization of something that is intensely complicated. But generally, if the copyright was registered, which involves paying a fee and filing your documents and your designs with the Copyright Office in Washington, if the copyright was registered before the infringement takes place, then the copyright owner, which in this case is you, is entitled to recover your attorney's fees if you are successful in filing a lawsuit against somebody and convincing a judge or a jury that there was infringement, right? So that's one advantage. The second is that you can opt to receive damages that are set by federal law within the range set by the Copyright Act, rather than having to prove how many dollars did you lose as a consequence of what the infringer did to you. And that's really an important concept, right? Because it wouldn't make sense for anybody to file a lawsuit and spend hundreds of thousands of dollars over years to win, and then get to a jury and have them say, congratulations, what you're entitled to is the $10,000 fee that you missed out on, right? No architect would ever want to go and file a lawsuit and spend years of difficult, struggle, proving it up and paying for it, and only to recover, a nickel. And so, again, we don't want to bring the claim, but an owner might realize that they can freely infringe on your plans because you're going to be disincentivized to ever bring a claim against them unless there are serious damages at the end of the claim waiting for you, right? So this is not about bringing claims. This is about motivation and leverage and what owners and their lawyers think about when they're thinking about what they could do with your plans if you're in a disagreement with them, right? So the measure of damages, and I apologize if I'm putting you to sleep, I'm married to a lawyer. I know we can be kind of boring, but the measure of damage is really important here because it goes to the kind of dollars you can recover, okay? And the measure of damages for copyright infringement specified by statute are your actual damages suffered as a result of the infringement and any additional profits that we can disgorge away from the wrongdoer, which is really hard to prove, like super hard to prove. And these are low dollars. They tend to be what fee did you lose out And again, it's generally not high enough to justify filing a lawsuit. But if you have registered your design with the Copyright Office prior to the infringement, right? And that's important because you can't be unhappy that something bad happened and then go register. You have to register prior to the infringement. Then you might get, in a lawsuit, the right to recover a certain dollar amount per infringement. And there can be tens of thousands of infringements within a single set of construction documents, plus attorney's fees. So if you have your copyright registered before the infringement, the kind of damages you could be entitled to could be in the millions and millions of dollars, and you don't actually have to prove what you lost out on, okay? And that's the sort of thing, I represent a lot of owners. If I'm looking at an architect that has their plans registered, and I'm advising an owner, and I'm thinking about, that we have a dispute with the architect, they're saying we don't have a right to use our plans, I'm telling the owner, this is the case where you might want to be really careful because that architect might actually be able to hit you for very significant damages. And again, it's not that I'm advocating that anybody bring the claim, I'm advocating that you understand the points of leverage and what an infringer might be thinking about. Should they surrender and compromise with you, or can they say, we're just going to infringe, it's no big deal, because there's no sensible architect would bring a claim when they're gonna be basically entitled to recover nothing. All right, so with that, I want to pivot now and I want to take a look at a paragraph that is a hypothetical clause that you would see in a contract. Now, this is not what you're going to see in the AIA contract because, as I mentioned, almost all AIA agreements that I'm familiar with, and I tend to work with all of them, and there are hundreds of them, the default is that the owner is going to get a license to use your intellectual property, not copyright ownership, right? But you might find a paragraph in a contract, whether it's an AIA agreement where the owner deletes what's there and adds this in, or whether it's just in a non-AIA agreement of some lawyer's creation, you might see a clause like this, which says essentially that the owner is going to become the owner of your works, right? So again, this is a contract clause that would be in a hypothetical agreement between an owner of a project and their design professional, okay? And to try to make this easier for you, because I know that this slide's a little crowded, when I click ahead, I'm always going to have yellow highlighting on what I want you to pay attention to. Because as you're going to see, this is going to get a little crowded. Hopefully this is not hard for you to follow. But what this says right now is that you agree that all the work that you prepare for the project, your drawings, your designs, your studies, your calculations, everything, prepared not just by the lead design professional, which is often the architect, although it doesn't have to be, but also their consultants of every tier, which we're defining as the design team. And collectively, all that stuff are the instruments of service. Whether they're halfway completed or fully completed, they're going to belong to the owner, okay? From the moment that you put your pen and you draw one line on a piece of paper, they own it, okay? And so if I was advising an architect about how we might change this up, if we were willing to give the owner copyright ownership, in order to make it a little bit fairer for the architect, that's what we're going to do right now. I'm going to walk you through my thought process. A lot of you might say, you know what, this isn't relevant to me because I'm never going to give copyright ownership over to the owner. I am always going to insist on just going with the AIA standard approach, which is licensure. So for those of you that have kind of gotten over that hump and you've decided, okay, I'm willing to give the owner copyright ownership subject to certain conditions, like what might those be? And again, this is not legal advice for you because if you just copy what I'm going to show you here, you're probably going to have a bad outcome because not every project is the same and not every contract is the same. So I would urge to not do to contracts I'm about to show you. I'm just trying to let you know what goes through my mind as I'm negotiating my way through an agreement when I'm representing an architect that is willing to give copyright ownership over to the owner. And again, you're going to see red language pop up on the screen. Those are new words that I am adding into the clause. and I'm going to highlight the words that I want you to focus on. Some of you might think that this first hypothetical edit is the blinding flash of the obvious. Yeah, of course. Like, I'm not just going to give the owner copyright ownership on my work unless I get paid. So like, foundationally, a lot of design professionals that are willing to give up copyright ownership to the owner are going to say, upon full payment by the owner of all sums owed to the designer under this agreement. Now, that's a little bit more nuanced than you might think, because does that include additional services fees that are disputed between the owner and the architect? Well, this reads that everything that you're owed to under this agreement, you need to be paid before the owner gets copyright ownership. There's room for quite a lot of disagreement about what that amount is. So even just putting these words in doesn't stop an owner from saying, I did fully pay you. I paid you your basic services fee. I don't owe you those additional services, and therefore I own the rights to your work. And then the architect coming back and saying, no, you stiffed me on these added services that I'm owed, so I own the work, right? So there's room for enormous disagreement even if you add those words in there. Right, and what you could see here is that first sentence that I added, the red words, upon full payment by the owner of all sums owed to the designer under this agreement, that is staying in this clause, but I want to highlight and draw your attention to the newer changes, which are highlighted here. So the other concept that I might advise an architect to think about is, does the owner own everything? Or do they just own the final part of the design? And so some design professionals might say, okay, if you fully pay me, I'm going to agree that you can have the final part of my work, the CDs in their final form that were selected by you, my client, the project owner, for inclusion in the project, but not the alternate designs in the work product that you didn't so select. So if, for example, you're an architecture firm that does, corporate office repositionings, and you bring a half dozen design concepts to the owner and they select one, the other 5 are still owned by you, and you can pivot off them and you can use elements of them in your next project for your next client, right? So we're going to strike the words whether completed or in progress, because we're not going to give the owner the drawing, we're not going to give them the SD or the DD. We're going to give them the CDs that you stamp and you issue for construction, and every other thing you're going to own. And so we're going to click ahead here, and I'm just going to apologize for the slide becoming a little bit crowded. I really don't know any other way to do this. But you could see here the new words that I've added to this clause are highlighted. We might want to clarify, even if you're willing to give the owner copyright ownership if they pay you, right? And even if you're willing to give them just the final portion of your works, you might want to clarify that they don't get your emails. It sounds a little silly, but in a dispute, when an architecture firm is emailing internally about whether or not they should be asking for additional services, what are the pros and the cons, and is it justified or not? I don't know that you necessarily want to hand those emails over to the other side if you get into a dispute. So you may wish to consider, defining, does it include, the final BIM model? Does it include in progress elements? If you're LOD 100, if you're LOD 200, does it include that? Does it include your emails? Or does it just include, the paper that you stamp and you seal, and maybe does it include, the final model where it's reached the level of development for issuance for construction. So there's room for so much nuance here that we're not getting into. I'm just trying to help you guys spot issues. And now we're starting to get a little bit crowded on the screen here, but I hope that you're all seeing that the red words that are appearing on the screen are words that I've added to this clause. And we've talked about all of them except for what I'm going to pivot to now, which is what's highlighted. And it says that I'll give the owner copyright ownership as long as I get paid, but just in the final works that were selected for inclusion in the project. But I'm not going to give them ownership of my standard details that I'm going to use for the production of all of the drawings and specifications on all my future projects. You need those things so that you don't have to reinvent the wheel on every single project. So notwithstanding the foregoing words, every member of the design team, right? Because you have to be concerned, if you're the architect, not just with who owns your work. This clause is giving away copyright ownership of the subconsultant's works as well, right? So if you're going to have a clause like this that says the owner is going to become the owner of anything, you better have a piece of paper with your subconsultants that say that you've got the right to do that. And that is where a lot of architects fall down. They'll sign an agreement like this and they'll give copyright ownership to the owner. And then in a dispute, it turns out they never owned the rights to the, MEP engineer's design. And the architect is in a world of trouble because they've given the owner ownership of something that they themselves do not own. So, notwithstanding the words above, each member of the design team is going to retain ownership of their respective typical or standard design details, depictions, instructions, specs. I mean, of course you guys don't go rewrite your specifications entirely for every project, but you better be careful that you don't give full ownership of a spec book to an owner if you don't own the words in there and if you're planning to reuse them. If these are things that are regularly used by you in the ordinary course of your practice that are not specific or unique to the project, right? I mean, I think that a lot of these things that I've said so far right now, you don't have to have a law degree to understand this stuff. I mean, this is the blinding flash of the obvious. You shouldn't give somebody ownership unless you get paid. They shouldn't get all your incomplete work. They shouldn't get your emails. And, you better not give away things that you don't own. And if you're planning to use something again in the future, you better not give it away. So we're carving out of the ownership rights that we're giving to the owner, your standard details and your subconsultant standard details, which are going to continue to be owned by them and you respectively. But of course, you're going to have to give the owner some rights in your standard details, right? Because they're embedded within your construction documents, which is why we have the next words that I've highlighted here, which, I'm just going to apologize again in advance that this slide is getting so crowded. But what's highlighted here is where we give the owner rights to use your standard details that are embedded in your CDs, okay, or embedded in your, Revit model elements, okay? And we're giving them a license to use those things for their particular project, but in a way that allows you to continue to use your standard details as you always do. So subject to the terms that are in this paragraph, the designer is going to grant the owner and is going to make sure that each member of the design team, which are the sub-consultants that are working under the architect, a non-exclusive license that cannot be revoked from the owner. So the owner, right, the owner, if they're going to hire you and pay you all this money, they have to make sure that they've got the right to use your drawings, and you can't put them over a barrel and say, give me my ad services or else I'm going to say you can't use these. So this is a non-exclusive license, but it's irrevocable. So you can't take it back. Of course, it's all conditioned on the first part of the paragraph upon full payment, right? So they don't get anything if they don't fully pay you. But if they do, a non-exclusive, irrevocable license to use and to copy the standard details for the sole purpose of this particular project, embodied in your issue for construction set of CDs. And, if, they're going to go and update or refresh the space in 10 years or 20 years, they've got some rights to use your works. Now, it kind of begs the question, what happens if someone changes my plans around in the future, and I get sued? Well, this is another huge oversimplification, but there's really two kinds of claims that you could face. You could face a claim from the owner. And, the words in this paragraph are really like a shield for liability. They protect you. But this paragraph is not going to protect you from all the other people that could sue you out there. If somebody slipped and fell in the space, an injured person, they don't have a contract with you, but they don't need a contract with you to sue you or anybody else who they think is responsible, right? Or if there's accessibility violations, the the highest operable part, the control is more than 48 inches off the finished floor, the center line of the toilet isn't 16 to 18 inches in the future. The Department of Justice could sue you for violating the Americans with Disabilities Act, or a disabled person or an advocacy group for disabled rights people. They could sue the architect or the contractor, the owner. They don't need a contract with you to bring that claim. So in the event that you face claims in the future from people other than the owner, the question becomes, how do you get protected in the event that it's 10 years down the road and another designer took your plans and they pivoted off it and they refreshed the space, and now there's a lawyer sniffing around to figure out who to sue? What happens if it's somebody other than the owner, right? Well, if you look at the last part of this paragraph here, it says that the owner is going to release the designer from all kinds of claims and expenses and damages and losses, okay? But only to the extent that all that stuff flows out of the owner's use or alteration of your instruments of service without your involvement, right? So that is a shield against claims from the owner, but that doesn't do very much for you against all the other people out there in the world that could bring claims against you. Heaven forbid it's an injured person or the Justice Department, all that stuff. We got to think about that kind of liability too, right? So we want to pay a little bit of attention to, how we protect you, right? And so I've highlighted language here that says that that if the owner uses or alters your instruments of service, okay, or anyone acting on the owner's behalf, right? Another design professional, an interior designer, contractors, tenants, successors in interest, who we're going to define as the owner's party without your involvement, it's at their risk, not yours, right? And you don't have any liability exposure for that. But again, those are all people that would be coming at you through the owner. This doesn't do much for third parties, okay? And so if we click ahead here, this is the language that requires the owner to protect you from the claims of others, right? That's what defense indemnification means. It means that if, heaven forbid, someone slips and falls in the space and they're injured, and they think that you may have been the one that issued the construction documents, and they're not clear on the difference between your work and the second architect that refreshed the space 10 years later, and they sue the both of you, the owner is going to have to protect you, right? They're going to have to mount a defense, and they're going to have to say, hey, injured person, no, that architect is not the one that's responsible for the space. They did work 10 years ago. Or, hey, Justice Department, or hey, disabled person, that first architect is not the one that allowed the center line of the toilet to be not properly 16, 18 inches from the wall. That was somebody else. So there's a lot that's going on here. And so I'm not suggesting that you cut and paste and put this into your contracts, because again, many of you might say, I'm never going to give copyright ownership over to an owner because I'm high design and it's just the way that I roll. But if you are a design professional who is willing to give copyright ownership over to the owner, and you're my client, I might counsel you along the lines of what we just discussed. And again, I'm not an intellectual property lawyer. This is one of 1,000 issues I deal with on behalf of design professionals. But this is what the clause would look like if the owner was willing to accept all of my suggested edits, right? And so in layman's terms, if the owner pays you, then the architect on behalf of themselves and their subconsultants are going to give copyright ownership of the final work to the owner. And if the owner uses that stuff without the design team's involvement, the design team doesn't have any liability to the owner. And in the event that, there's use or alteration of your instruments of service in the future and it leads to claims of third parties, the owner is going to protect you and your subconsultants. And even though you're giving ownership of the copyright over to the owner, which wouldn't be a good idea if you're Frank Lloyd Wright, and you're going to have a second prairie style home, we're not going to give the owner the standard details that appear in all of your documents, when you're producing your construction documents, but you're going to give them a license to use those for that particular project. So a lot of words. I know that you guys went to architecture school, not law school, for a reason, and this kind of stuff might be boring and annoying. But this is kind of what goes through my head when I'm thinking about how to edit a document in a way that would be fair and reasonable, and most owners would agree to a lot of this stuff. I don't know that they all would. I don't know if I'm representing the owner on your next project that I'm going to agree to all this stuff if I'm representing the owner, but this is like a head fake in the direction of what's reasonable. So edits that vibrate roughly on this frequency are things that are typically within the bounds of what people can agree to. So now, in the last minute or two before I'm going to throw this open to questions, and please don't be shy. I'm just a guy, I don't bite. There's no such thing as a stupid question. And, if you don't want to ask a question now, my contact information is at the bottom of the slide deck here. You can find me on my website at buildchicagolaw.com. And if you call me or you email me, it'd be my pleasure. I'm looking to make new friends in the design community, and I'm not going to bill you. So please do ask questions with the last 10 minutes, and please do feel free to call or email me, particularly if you'd like a copy of the slide deck. I'm more than happy to share this with you all. So what's interesting, in intellectual property right now? I think that we're all struggling with what artificial intelligence is going to do for us in our practices, good and bad. And I am trying to build a large language model right now that I'm going to train to help to redline contracts as a first cut, so that, the associate lawyers that I employ in the next rooms over can use a computer to have the first stab taken at how to edit a contract. But how do you guys think about AI? And one of the things that I thought was most interesting when I was listening to a very smart general counsel for a large design firm the other day speak is he was wrestling with the question of what happens when an owner comes to you and says, hey, architect, I don't need to pay you for concept design. I don't need to pay you for the early part of schematic design, because you know what I did? I took your portfolio online, I took your photos, and I took your renderings, and I threw it into AI, and I created my own concept design for the project that I want you to design for me. So let's talk about, you picking up halfway through the SD phase and how much I'm going to pay you for DD and CDs. And we could talk about what I'm going to pay you in CA, but you don't got to worry about concept design because AI did the concept design for you. Well, the first thing you should be worried about is, those pictures that you have on your website of the beautiful skyscraper that you designed 10 years ago for, a client, 100 clients ago. What does your contract say with that owner 10 years ago about who owns the design? Do you own it, or do they own it? Would your next client have a right to use AI to copy elements of a design that you created years ago? Or does the owner of that project from 10 years ago have the right? Is your next potential client infringing through you on rights of your old clients? And the concerns are, you getting sued for violating contracts that you signed 10, 20 years ago. When your owner gets your former client from years ago gets their nose out of joint because all of a sudden there's a building that has elements that looks a lot like theirs, and you're the architect that did it. So are they going to sue you? But then, of course, the in-house attorney for the large design firm was also concerned about loss of fees, right? And then, of course, I'm sure you're all grappling with production efficiencies from artificial intelligence. How can you guys make more money by using AI to, help you to produce your working documents? This is something that I'm sure a lot of you are grappling with. You got to be careful that whatever you're feeding into AI, that you own the rights to that stuff if you're going to use it for production efficiencies. And so we are in the first moment of creation right now for thinking about what AI means for design professionals in terms of opportunity, loss of opportunity, fees, danger, and whatever I know about this subject and whatever you know, check back in 5 minutes because it's going to change. So with that, I'm going to just show you real quickly that I represent a few dozen design firms. Architects are most of my clients. If you had a copy of this slide deck, you could click these blue links and they will take you to videos. I've got more than 100 videos on my websites about things that might be of interest to you. I've got lots of videos about contract negotiation. If you want a copy of this slide deck, you can get it from me. Just email me, call me, or you can go to my website, buildchicagolaw.com, and you can find all these videos. There's tons of articles on my website that are also educational, that are meant for people like yourself. This is just a small smattering. I try to update it regularly. And lots of content for architects and engineers and developers. And I hate litigation, and I'm all about how to resolve disputes quickly and efficiently if we can't get around them. And so with that, I'm going to wrap up my portion of the presentation with my contact information and just this disclaimer that I'm required to have here, which is none of this is legal advice for any of you. And with that, I hope that there are some questions.
Fantastic. Thanks, Jeremy, so much. We do have a couple of questions. So let's start off right off the bat. Are projects registered with the U.S. Copyright Office visible to the public?
That is a good question that I don't know the answer to. I think that the answer is probably yes. I think that you can look, I would be willing to bet that you could look up and get some information about who has registered copyrights and who has not. So I think if you're wondering whether the owner would be able to figure out whether or not you registered the project, my guess is that they probably would. Whether or not the Copyright Office would display everything that you have to give them when you register, which are renderings and drawings, and you almost have to kind of do it in SD and DD and CDs. Whether or not the public would have access to all that stuff, I would tend to doubt that that's the case. But I'm not ashamed to tell you that I don't know the answer because, as I mentioned before, I handle 1,000 issues for architects, and this is just one of them. And my clients really seldom tend to register their designs. So I don't really know. If you want the answer to that question, call me or email me. I'll try to figure it out for you.
Awesome. Thank you. And we have another question here. Under what conditions would you advise registering an architectural work with the Copyright Office?
Bearing in mind that there's costs and there's hassle associated with it, and it's going to be up to the architect to make the business decision about whether it's worthwhile for them to do that. If I have a client that is starting to get a feeling that their project might go south and it's early in the project, or if it's a substantial project, I might talk to them about this might be the one project in 1,000 where we want to take that steps, not because we want to pick a fight, but because in the event that you're right about things getting challenging in the future, boy, it'd be really nice to be able to go to the owner in the future and be like, you know what? Look at this certificate here that says I registered my copyright with the Copyright Office, because that is likely to deter them from doing things that would require you to be in a lawsuit with them. So it's not that we want to get the damages, it's that you want that piece of paper, because if I represent an owner and they say, I want to fire the architect and I want to build a project and there's a question about whether we own this or not, Jeremy, what should I do? The first question I want to know is whether or not the architect has registered that design or not. And I mentioned it earlier, it bears repeating, that you have to register it before the infringement takes place. So if you've already submitted your drawings for permit approval and they're available to the public, it might be too late. And so I know that some of the panelists were asking me in the prep session, how early do you have to register these things? Here's a really weak answer. It depends. early enough, certainly before the infringement.
Great. So our next question is, how is intellectual property managed when the interior designer and the architect of record collaborate on a project? Who owns the intellectual property when both are contracted by the owner?
If it all depends on what your contracts say. So if the interior designer and the architect are both in direct contracts with the owner, then whatever the words are in the paper that you sign as the architect with the owner on the one hand and with the interior designer and the owner on the other hand, whatever words that are in there, that's the answer to the question. If you give them a license to use, that's all they got. If you give them copyright ownership, that's all they got. Now, it's a little more nuanced when the architect sub-consults the interior design work out. So if the architect is in the middle of the contract chain and the architect has an upstream contract with the owner and a downstream contract with the interior designer, the answer is still the same. Look at the contract and see what it says. But as I mentioned before, a well-advised architect is not going to promise rights to the owner that they don't have. So, if the interior designer's agreement with the architect says that the interior designer owns their copyright, and the owner goes and tries to give it away to the owner, there is going to be an aggrieved owner and an aggrieved interior designer, and the architect in the middle could be in quite a lot of hot water. So I hope that answers the question.
I think we have time for maybe one more question. So if the owner has the copyright to a drawing set or a design, and the owner tries to use that drawing on a property where the soil doesn't accept the design or the code doesn't apply, can the owner go back to the architect and have the architect redesign without additional fees? Or should that be clarified in your contract that the design is specific to the property?
The answer to this question, like the answer to almost every question, is it depends what the contract says. And that's the real trick about negotiating contracts is that when I am working on a contract, it can't be too long because we don't want to annoy everybody with too many words. But if I really wanted to protect everyone against every particular risk, I'd have to write contracts that are 1,000 pages long. And if I tried to do that, I wouldn't have any clients because my architects would know that they're gonna annoy their clients, the owners, with my edits. So there's a balancing act in every contract. How many words are too many words and how many are too few? It's something that it balances on the knife's edge, and there's a standard of care for lawyers, just like there are for architects. But like whether the owner can take what you designed and use it anywhere else depends entirely on the words in the contract. Whether they can use it somewhere else without paying you or whether they've got to pay you some kind of a fee depends entirely upon what the words are on the contract. If the soils are unsuitable, and the owner had the right to use your documents there, did you commit design malpractice? Probably not, but the standard of care for architects is a really amorphous thing. In all of these disputes, you're going to have one side hire an expert that says this is what the standard of care is and it's violated, and you're going to have the other side say no, the standard of care is this, and it's not violated. And so read your contract. Words matter. They're the answer to almost every question that you could ask me.
Fantastic, Jeremy. Thank you so much. I'm going to turn it back over to Sherry to wrap things up.
Great. So Jeremy, and thank you, Anne, for helping with the Q&A. What a fantastic session, enlightening, frightening, and all the things at once. As Jeremy recommended, please reach out to him with any questions you might have. And we look forward to seeing you at the next event for Practice Management KC, which will be coming up in November. So thank you, everybody, for joining us, and have a great day. Take care.
Thank you.